Equal Employment Opportunity Legislation, Leigh and Stuart, Human Resources Management at Milligan College. The first equal opportunity law that we will cover is Title VII of the Civil Rights Act of 1964. This act prohibits discrimination on the basis of race, color, religions, sex, including gender identity and sexual orientation, or national origin. This act also established the EEOC, or the Equal Employment Opportunity Commission, as an enforcement agency. This applies to employers with 15 or more employees, including all private employers, federal, state, and local governments, educational institutions, private and public employment agencies, labor organizations, and joint labor management committees, apprenticeship and training programs. And of course, it is enforced by the EEOC. Looking a little further into the Civil Rights Act of 1964, we find that Title VII explicitly addresses discrimination in the process of employment. The best understanding of this law comes from examining the protected classes, which are race, sex, including gender identity and sexual orientation, religion, color, national origin, age, over 40, disability, veteran status, pregnancy, and genetic information. The Civil Rights Act was monumental legislation to address the growing issue of discrimination. If we remember, separate but equal, back of the bus, separate water fountains, schools, cafeterias, and other public spaces. The civil rights movement of the 1960s shed light on the need for reform. Peaceful protesters were beaten by police. This abuse galvanized the nation and forced it to confront the issue of discrimination. The passage of President Kennedy's Civil Rights Bill was a top priority for President Lyndon Johnson in his first year following President Kennedy's assassination. President Johnson organized groups and individuals to assist him with its passage. This included the NAACP, the Leadership Conference on Civil Rights, and members of the House and Senate, specifically Senators Hubert Humphrey and Everett Dirksen, and Representatives Emanuel Celler and William McCulloch. Republican Senator Dirksen was a key to the passage of the Civil Rights Bill. While he had previously opposed the bill, he felt it was an idea whose time has come. Passage of the bill occurred on June 19, 1964, exactly 1 year after President Kennedy introduced the bill. President Johnson signed the Civil Rights Act of 1964 into law on July 2, 1964. The next equal employment opportunity law that we will discuss is the Equal Pay Act of 1963. This act prohibits discrimination in pay on the basis of gender for individuals performing jobs with the same skill, effort, responsibility, and working conditions, unless there is a factor other than gender used to determine the pay difference. This was among the first federal laws in American history to address gender discrimination. Differences in pay are allowable if based on merit, seniority, quality, or quantity of production. This is enforced for all employers with one or more employees, including the federal government, and is enforced by the Equal Employment Opportunity Commission. If we examine the history of the Equal Pay Act of 1963, we find that in 1942, the National War Labor Board endorsed policies to provide equal pay in instances where women were directly replacing a male worker. And this was because American women had assumed the factory jobs left open by the men that had enlisted in the military during World War II. In 1945, the U.S. Congress introduced the Women's Equal Pay Act. This law would have made it illegal for pay disparity between men and women for equal work. However, this measure failed and there was little progress within pay equity throughout the 1950s. On June 10, 1963, President John F. Kennedy signed the Equal Pay Act into law with support from Esther Peterson, head of the Women's Bureau of the Department of Labor, and Eleanor Roosevelt, chair of the Presidential Commission on the Status of Women. The next Equal Employment Opportunity law that we will discuss is the Age Discrimination in Employment Act of 1967. This act prohibits employment discrimination of individuals aged 40 or older. This was the result of employment practices that provided preferential treatment to younger individuals and even fired older workers to prevent payment of retirement benefits. Enforcement is all employers with 20 more employees, including employment agencies and labor organizations, federal, state, and local governments, and school districts. It is enforced by the Equal Employment Opportunity Commission. Looking at the history of the Age Discrimination in Employment Act of 1967, we find that this act was passed after a Department of Labor study illustrated widespread age discrimination in businesses across the country. The lower age limit, age 40, was a compromise of much debate in light of female flight attendants stating that they were being forced out of their jobs in their 30s. Originally, the law covered an individual until age 65, and companies continued to force older workers into retirement. Due to the fact that people were living longer, the upper age limit was found discriminatory and was banned in 1987. This act also covers early retirement packages, which means that an early retirement package cannot be offered to workers age 55 through 60 and discriminate against the employees older than age 60. It is important to note a few of the exclusions in the Age Discrimination in Employment Act of 1967. Early retirement incentives are allowable as long as there was no coercion and the package was presented in a way that was easily understood. Bona fide occupational qualifications are allowed when a company can show that age interferes with performance or safety. Mandatory retirement of high-ranking executives is allowed as long as the benefit package guarantees a particular level of compensation. The next Equal Employment Opportunity law that we will discuss is the Pregnancy Discrimination Act of 1978. It specifies that women who are affected by pregnancy or pregnancy-related conditions are to be treated the same as other applicants or employees with similar limitations or disabilities. Employers cannot refuse to hire a woman because she is pregnant, nor can an employer fire a woman because of her pregnancy. This covers employers with 15 or more employees, including all private employers, federal, state, and local governments, educational institutions, private and public employment agencies, labor organizations, and joint labor management committees controlling apprenticeship and training programs. It is enforced by the Equal Employment Opportunity Commission. If we examine the history of the Pregnancy Discrimination Act of 1978, we find that it was an amendment to Title VII of the Civil Rights Act and was a reversal of the Supreme Court decision in General Electric versus Gilbert. This decision held that the General Electric health plan did not discriminate against women by not covering pregnancy. However, Congress reversed the decision in Gilbert by passing the Pregnancy Discrimination Act. The Pregnancy Discrimination Act was expanded to include broad anti-discrimination protection, not just an insurance coverage. It held that all women with a pregnancy or pregnancy-related medical condition must be treated the same for all employment-related purposes. The next Equal Employment Opportunity law that we will discuss is Immigration Reform and Control Act of 1986. Documented immigrants have legal right to work and are protected by the Civil Rights Act of 1964. This act covers unauthorized immigration. In 1986, Congress passed the IRCA to control unauthorized immigration to the U.S. and was signed into law by President Ronald Reagan. But actually, the work for its passage began with President Jimmy Carter. There are three major components of the law: tougher border enforcement, penalties for employers who hire unauthorized immigrants, which we will discuss further, and legalization for unauthorized immigrants who have been in the U.S. for 5 years or more. The Immigration Reform and Control Act of 1986 is a little different than the other equal employment opportunity laws that we have discussed. The employment section of this act is intended to protect the employer from fines and possible jail time for repeated offenses as a result of employing unauthorized immigrants. This act is enforced by the Immigration and Naturalization Service and requires employers to collect INS Form I-9 as well as proof of identity. It is the employer's responsibility that anyone they hire has a legal right to work in this country. It is recommended to wait until a job offer is made to collect these documents in order to avoid a violation of the Civil Rights Act of 1964 based on citizenship. The next equal employment opportunity law that we will discuss is the Family and Medical Leave Act of 1993 and 2008, otherwise known as FMLA. FMLA provides for up to 12 weeks of unpaid leave to an employee to take time away because of personal illness or to care for a sick member of their immediate family, defined as child, spouse, or parent, or for the birth, adoption, or foster care of their child. It was amended in 2008 to include leave for family members of military about to go on or on active duty for qualifying reasons. As well, it added 26 weeks of leave to care for a wounded soldier. In 2015, the definition of spouse was updated to recognize same-sex unions. This is enforceable with employers with 50 or more employees in a 75-mile radius. Employees must have at least 1 year employment and have worked 1,250 hours in the preceding 12 months. The Family and Medical Leave Act of 1993 and 2008 has a 10-year history prior to its passage. President Bill Clinton signed FMLA into law on February 5, 1993. It was his first piece of legislation as president. To this day, it remains the only piece of federal legislation specifically focused on helping workers manage their dual responsibilities in the workplace and in the home. It acknowledged the new reality that more than half of mothers were either a breadwinner for their families or shared that responsibility with a partner, which has only increased in the decades since its passage. It was initially drafted and passed a decade prior while President Reagan was still in office, but was vetoed by President George H.W. Bush. Of note, his son, President George W. Bush, vetoed an expansion of FMLA to provide up to 26 weeks of unpaid leave to workers who are caring for a wounded service member in active duty, which was later signed into law by President Barack Obama. The next equal employment opportunity law that we will discuss is Title I of the Genetic Information Act of 2008. This act prohibits discrimination against employees or applicants because of genetic information and restricts requesting, requiring, or purchasing genetic information, as well as disclosing such information. It is enforced by the Department of Labor's Employee Benefits Security Administration and applies to employers with 15 or more employees, including all private employers, federal, state, and local governments, educational institutions, private and public employment agencies, labor organizations, and joint labor management committees controlling apprenticeship and training programs. In a review of the background history for Title I of the Genetic Information Act of 2008, we find that the Coalition for Genetic Fairness was founded in 1997 to address the growing concern surrounding the misuse of genetic information in health insurance and employment decisions. It was signed into law on March 21, 2008 by President George W. Bush. This law protects those individuals that wish to have genetic screenings, counseling, testing, and therapies. It applies to discrimination by both health insurers and employers. It cannot be used to deny health insurance coverage, nor can it preclude an applicant from employment or be used to terminate an employee. The next few slides will discuss equal employment opportunity from a Christian perspective. Equal employment opportunity laws are designed to protect vulnerable classes of people from employment discrimination. However, there are still some instances where individuals are not afforded full protection from such discrimination. First, most of the equal employment opportunity laws covered in this presentation apply only after a company employs 15 individuals. From a Christian perspective, it would be difficult to uphold the biblical values if working for a company that is allowed to systematically discriminate against applicants or employees in a protected class. Secondly, The Family Medical Leave Act provides protection for up to 12 weeks, but is limited in scope based on time worked and number of employees required. From a Christian perspective, it would be difficult to terminate an employee with an illness that did not allow the person to return within 12 weeks or that wasn't eligible for coverage. Third, the Equal Pay Act allows pay and equity based upon merit, seniority, or quality and quantity of production. The vague language is open to interpretation by employers and sometimes leads to something as simple as a job title change for legal gender-based pay discrimination. Christian leadership should be troubled by maneuvering the law to allow gender-based pay discrimination. Lastly, the Immigration Control and Reform Act of 1986. It is important to ensure that individuals have a legal right to work in the United States. The Bible upholds the requirement to obey governmental laws in Romans 13. However, Christian HR leaders may find it difficult within their heart to deny jobs to individuals that come to this country seeking a better life or fleeing from rampant violence in their home country. Nevertheless, they must obey this law or face fines and/or prison time. In conclusion, this presentation has covered 7 equal employment opportunity laws that are designed to protect individuals from discrimination in the employment process or in the workplace. However, multiple complaints to the EEOC continue today. In response, HR leaders must pray for wisdom and discernment to ensure that they promote and abide by the practices and laws that protect vulnerable members of the society in their quest to seek meaningful employment to provide for themselves and their families. References, page 1. References, page 2.